Welcome back. This is the Ben Shapiro Show. Well, we've been watching as controversy brews in the Trump administration over the firing of the Navy Secretary. The Navy Secretary apparently fired because he disagreed with President Trump about military discipline for particular members of the military who had been tried on charges ranging from murder to taking photos with dead bodies, acquitted. I mean, all of it's a mess. Joining us on the line to discuss is Cully Stimson, Senior Legal Fellow at the Heritage Foundation, former U.S. Navy Judge Advocate General's Officer. Cully, thanks so much for joining the Ben Shapiro Show.
Always happy to be with you.
So why don't you explain for people who haven't been following this closely, what exactly is going on with the Navy Secretary? Why is this a controversy?
It's controversial because Chief Eddie Gallagher was a Navy SEAL, distinguished warfighter. He was charged and court-martialed, which is a criminal trial, for murdering an unlawful enemy combatant. A shipmate of his, a former Navy SEAL, testified during the trial after he was given immunity that, in fact, he's the one that killed him by putting his thumb over the trach in his throat during his dying moments. Gallagher was acquitted, but he was convicted by a court-martial of his peers of posing with a corpse. Earlier, before the trial started, but while he was in jail pending trial, Trump called the Navy Secretary and said, "Get him out of the brig. He does not need to be in the brig." So the Secretary said, "Aye, aye, sir," and let him out of the brig. And then fast forward to the last few days, the Navy routinely, after people are acquitted of criminal conduct, think about whether or not they should just fire the person as an employee. So they were going to send Gallagher, the Navy chief, who had a trident pin, which is the coveted gold pin on his chest, before a trident review board to see whether they should at least strip him of the trident. And Trump tweeted a few days ago, "Nope, keep him his trident, get him back to work." And so what the Navy Secretary tried to do in an awkward way was to go to the White House and say, "Look, okay, you tweeted this. Is it really in order? And if it is, what do you want to do?" Well, what Spencer did not do, the Navy Secretary, is go to the Secretary of Defense and say, "Hey, look, I got a problem here. I want to obviously follow orders, but I want to work out and figure out what the president wants." And so when the SecDef found out that the Navy Secretary went directly to the White House, the SecDef talked to the president, and the president agreed that the Secretary of the Navy should be fired, and so the SecDef fired him.
Okay, so with all of that said, we're talking with Cully Stimson, Senior Legal Fellow at Heritage Foundation and former U.S. Navy JAG. With all of that said, there's been a big controversy that seems to be brewing over how much the president should interfere in the military justice system. Now, obviously, he's commander-in-chief, but as a matter of good policy, should the president be interfering on isolated cases like this and sort of inserting himself in the process of military justice? There are a lot of folks on the right who've been suggesting that the military has become too politically correct, too sensitive to outside influence, and thus they've been cracking down too hard on members of the military for mistakes, and the president is correcting that. Well, where do you come down on this?
Now, I'm in the Navy still. I'm a captain, which means I'm old. So I'm a senior officer, but I'm speaking on behalf of the Heritage Foundation as a heritage scholar. I think it's rare when presidents weigh in on matters like this, but it does happen. Remember, Obama, for example, commuted the sentence of Chelsea Manning, and that was very controversial. He was sentenced to 35 years, which he richly deserved, and Obama gave him time served, took away that time. Here, I think it was probably imprudent of the president to do it because the president's impulsive, as we all know. The president became very involved in this case. The military justice system is a really good system of justice. It's different than the civilian world. It's there to enforce good order and discipline. It's there so our warfighters can win wars in a lawful way. And so here, I think the process should have played out. At the end of the day, if the process played out and the administrative board decided to fire him, the president could have said, "No, keep him as a chief. Keep him his trident and let him retire with honor," and that would have happened. But here, the president inserted himself in the process numerous times along the way, and it put the Secretary of the Navy and the Secretary of Defense in a very awkward situation, and especially the chairman of the Joint Chiefs of Staff, that senior uniformed person. And so I think it was imprudent. I think it disrupted the normal course of things, and I hope it doesn't happen again.
Well, speaking in your capacity as an expert at the Heritage Foundation, Do you think that it is true that the military justice system over the years has become too sensitive and that we ought to be relieving pressure on members of the military because again, the idea is that press critiques have decided coverage? Or do you think that there is a fairly consistent system of justice that's been applied for years and that sticking to the rules as they've been given is a better idea than sort of adjudicating these things in the public press?
I commend the Congress, frankly, Ben, on finally rewriting and updating the Uniform Code of Military Justice and the Military Commissions Act of in the Military Justice Act of 2016. But Congress is to blame just as much as presidents are. Congress has been putting pressure on the military, especially the military justice system and senior commanders, to hold people accountable for sexual assault. They tried to change the rules. They did change the rules for a few years, which made it unfair, difficult to prove. And in fact, senior appeals courts in the military struck down one of the statutes that Congress passed. And so when Kirsten Gillibrand, the senator from New York, tries to strip commanders of their ability to refer cases to court-martial and set up so-called independent prosecutors, that's not a wise, prudent move. Nobody in the military thinks that's a good idea. That caused problems. There's a lot of pressure from Congress and the press to change the military justice system, but it is a very good system. It's the best military justice system in the country, but senior military people watch and read the news, and they feel the pressure. But we have independent judges in the military. I was one for a while, for 5 years. We try to ignore that. We do ignore that and just follow the law. And so I think here when the president reached down and did what he's lawfully allowed to do without letting the process play it out, it disrupted the normal course of things in the military justice system.
Well, Cully Stimson, Senior Legal Fellow at Heritage Foundation, former U.S. Navy JAG, really appreciate your time. Thanks so much for what you're doing. Talk to you soon.
Thank you.